Caveat emptor. Is it a fancy Latin appetizer or is it a legal description? We're going to discuss that today, and I'm joined by Harold Hudson, who's the managing partner with the Hudson Law Firm here in Atlanta. And Harold, boy, you guys, you lawyers love to throw these Latin terms around. What in the world does caveat emptor mean, and why, as a residential real estate agent, would I care?
Okay. So caveat emptor is a Latin phrase that means literally, let the buyer beware. So let the buyer beware. Sellers love that phrase, I think. And basically, it's very different. It means a lot of different things in different states. So one of the overriding things that you have to know is that people in Florida, Texas, California, New York, these laws are very state specific. And Georgia has some very state specific laws that relate to caveat emptor, let the buyer beware. What is it under Georgia law that a seller has to tell a buyer about the property that the buyer is looking to purchase? So can the seller say, hey, I don't know anything, do your own home inspection, it's all up to you, I'm not going to tell you about the buried gas tank out back? What can they do? So under Georgia law, generally, sellers do have a duty. And they have a duty to tell of any latent defect that may exist or does exist to their knowledge on the property. So a latent defect is something that basically would not be discoverable, easily discoverable in a home inspection. So if there's been flooding before, but the seller has had all the baseboards removed, there's no evidence of the flooding, as a seller, do I have to disclose that? So generally the answer is yes. So also, listing agents, the agents for the seller also have a duty under Georgia law that if they know about these defects that a ordinary buyer would not discover, would not know about, that flooding that occurred 5 years ago that I fixed, they have a duty to disclose that as well.
Now, generally, in the state of Georgia, a residential real estate agent will give the seller a property disclosure form. As a matter of fact, the Georgia Association of Realtors has a standard form for property disclosure. If a seller does not adequately fill out the form, unbeknownst to the listing agent, does the listing agent still have any liability if the listing agent, by walking around the property, actually sees something that may cause them suspect, maybe flooding, maybe past termite damage, but the seller has not disclosed that on the form? What's in it for the listing agent, and what's their liability?
Well, yeah, sure. The listing agent has a liability and obligation. I mean, real estate agents are licensed professionals in the state of Georgia. So there's a set of rules, ethical rules that they have to abide by, and there's a set of laws that they have to abide by. So again, if the agent discovers something about the property independent of what they learned or had a communication from the seller, they have to disclose that. And so my experience is that there is a group of agents that will be on it, and they go through these disclosure forms item by item, page by page, because they're multi-page documents. They go through, how about the roof? When was the roof replaced? How old is the roof? Has there been any roof damage? Have there been leaking to the roof? What about the HVAC? When was the last time it was serviced? It goes through every system that a house would have. It goes through the structural components of the house. So I think that probably the best practice for an agent is to go through those and be serious with your client, the seller, and that they accurately disclose these items, because the chances are they're going to be found out. Maybe after the closing, but they're going to be found out.
What about from the buyer's agent's perspective? You know, a good buyer's agent has just as keen an eye as a seller's agent. And if a buyer's agent comes in and sees something that looks like termite damage or maybe flood damage, even prior to a home inspection, or what are the ramifications if a buyer's agent doesn't say anything to their buyer?
Well, I certainly hope that wouldn't be the case, but they're certainly not doing a very good job representing their buyer if that's the case. But they have an obligation as well to, I mean, this is just not going and getting a $5 plaque from some state agency. I mean, there are responsibilities and duties that agents have, and they just need to know about them. So obviously they need to disclose that to their client, or else they could get in trouble.
What about recourse? All right, so something happens, we go to closing, we close on the property, and then the buyer finds out that not only was something not disclosed on the property disclosure form, but by the new buyer talking to the next door neighbor, and the next door neighbor certainly telling them that, oh yeah, well the big oak tree fell on the corner of that house and the place flooded 2 years ago, and I helped Fred, clean up the mess in the bedroom. Now all of a sudden none of that was disclosed. The neighbor has just said that it happened. Nobody disclosed it. Who's in trouble now?
Well, could be a lot of people in trouble. And I guess the big question is, you've closed, you're the buyer, you've closed, the transaction's over with, sellers got their money. Who knows if they moved to Florida, if they have any, or spent the money, or what? So the question is, what do you do about that? And it does occur pretty frequently. And so there are some self-help measures. I get a lot of questions. Hey, Harold, you were the closing attorney on this. We borrowed money from Truist to buy this house, and you did our closing for us. And the seller did not disclose that there was a problem with the septic tank. We moved in, and there's a lot of problems with the septic tank. Neighbors told us that the septic company was out there last week, whatever. So what can they do? So my first comeback to somebody's asking me that question is that, look, I represent Truist Bank, the lender in this transaction. Recall, that's what your purchase to sell agreement. I wasn't involved in any of these work in the contract. I got involved. I got the contract. Everybody had signed. All those disclosures, everything has been done. So I represent the bank. I don't represent the buyer or the seller. So I can't represent you. So what do you do when you hear that? You're a buyer and you go, well, here's this guy who's done with the transaction, doesn't want to have anything to do with me. So that's not the case, but I can't represent you in that action. So there are a number of things you can do. Self-help. What can you do from a self-help standpoint? Number one thing I would do is have your real estate agent contact the real estate agent for the seller and talk about this. And if that doesn't get anywhere, then have your agent go to their broker and let the broker talk to the broker of the agent who represented the seller. Next step, if that still doesn't work, then the next step is to, you could go and file what we call a small claims court action. So if the amount of your damage as a buyer that you need to go out and fix that septic system is going to be $6,000, let's say. If the amount that you're going to be suing the seller for is less than $15,000, and we have what's called a magistrate court in Georgia, every county's got one. You just go online. You can pay online. You can fill out your little bitty complaint. You can pay the sheriff to go serve the seller with the lawsuit. Now, that sounds simple. And basically what happens, if that occurs and that's your route to take, then you basically have like a people's court that you see on TV, Judge Judy, something like that. It's not as glamorous as Judge Judy. But you have, or for older people, Judge Wapner, the people's court. So basically it's just basically you go down there with your documentation and the seller has to show up. If they don't show up, then you get a judgment against them, and then you sort of do a little people's court in there. So that is an avenue to take, but the problem is you have to serve the seller with a lawsuit. And what if the seller moved to Florida? You know, are you going to try to go and sue somebody? Are you going to go and hire a lawyer to try to sue this person? You're going to pay the lawyer $10,000 for a $6,000, you know, fix on a septic tank. So it can leave a buyer in a no man's land, if you will. Sure, you can sue them, but you know, what do you get? I mean, it's unless you have a big damage, you're probably hiring a lawyer is not going to be the route to go. So this small claims court, magistrate court, is really the way to go if you have a issue like that.
So buyer beware is not an appetizer. It's a big deal. It's up to you to have a very good inspection. And from the perspective of a real estate attorney, all right, any of these legal proceedings, at least from a residential real estate perspective, residential real estate agents do not get involved in legal advice or financial advice, and it's always referred to the law firm like Harold. So in a situation like this, Harold, if someone has a question, I depend on you quite often for this sort of thing, but if there's another residential real estate agent out there that may have a question, how do they get in touch with you?
So a lot of easy ways to get in touch with me. I want to touch back on one thing.
All right.
On caveat emptor and let the buyer beware. So that's not really true in the state of Georgia. If you know something that has occurred, you need to be truthful and tell the buyer about it, because as you just said, Pete, most buyers, in the red hot market we had, there were people that were buying houses without a home inspection. Because if you, Pete, insisted on a home inspection, but I did not, guess who's going to get the house? Mm-hmm. So I think that those days have passed, and I'm not sure they existed. There were some agents who were willing to do that, and I heard their rationale, and maybe it was sound rationale, I'm not sure. A lot of agents were not willing to allow their buyer to purchase a home without a good home inspection. So the thing is, if you don't disclose something on your seller's property disclosure form, and then it comes up during the inspection, you're going to look foolish. And the buyer is going to say, how can I trust this seller? If they didn't disclose this, and it was obvious, and my inspector found out, because I didn't find out, I didn't know it, that paint in a basement in a certain area would indicate that there's been some remediation down there. But my home inspector, that's a telltale sign. They knew exactly when they walked in there, they could smell it, they knew exactly the rust color, they chipped behind the paint, and they saw what was behind there. So if you don't disclose, and then during the inspection period, after the inspection period, you find these things out as a buyer, you've lost credibility with your buyer. And so that's going to cause your buyer to potentially cancel, terminate. And I think the good agents that come along with the next buyer are going to ask, hey, why did that terminate? What happened? And so you're just going to be digging your, I mean, I hate to say it, it sounds old-fashioned. Honesty in this regard is really the best policy. It's going to serve you. There are other ways to make money, but not disclosing something is not a way to do it. So if you have a question about any of this stuff, you can call our office, 678-999-6030, 678-999-6030. We have a very experienced staff, and they may be able to answer the question off the top of the head. If they can't, they're going to give it to one of the attorneys, to me, potentially. You can send us a text, 404-863-5338. Saturday, Sunday, whenever, just send me a text, 404-863-5338. That's my business cell phone. Or send us an email, harold@hudson.law. It's .law, not .com, harold@hudson.law. There's a lot of people in our office who are recipients of that email, even though it says it's mine. A lot of people are looking at that and will respond as quickly as possible.
And there you have it. Let me also point out that Harold has written a book. It's called Asset Protection in Georgia. It's a tremendous book for anyone that has assets in the state of Georgia, whether they're your residential house, your small business, could be trust. But if you will simply click on the link below in these show notes, you'll see it'll take you to the website. If you'll give us your name and where you want us to mail the book, we'd be happy to do that. Also, if this video has been helpful, we'd certainly appreciate clicking the like button below or even the subscribe button over here. And anytime you click that subscribe button from now on, as we have new videos that come out, you'll be notified and you'll be able to stay up to date with the latest and greatest and the legal ramifications of residential real estate in the state of Georgia. And until the next video, we'll see you.